Good evening. So it is 5:35 p.m. And call this meeting to order. And before we even do the Pledge of Allegiance, I just want to bring to attention, this is a reset from the scheduled meeting of last week. And do we need a motion to approve having holding the meeting this evening, since it's the second Thursday of the month?
I'll move the meeting from December 7th to December 14th.
Seconded.
All in favor?
Aye.
Thank you. All right, and let's go ahead with the Pledge of Allegiance.
I want to go home.
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You want to just declare that we have a quorum? One.
Yes, Grand Williams,
Here.
Burdick,
Here,
everybody's here, but Weiss here. And Jackie, you're here. Thank you.
Chair, can we just ask everyone before you speak to just state your name before you start speaking? That would just help with the recordings.
Sure.
If you could just speak, thank you, say your name.
Okay, Judy Stern, Chair. Approval of the corrected September 7th meetings and November 2nd meeting. Do I hear a motion?
I would like to discuss, if you want to move first, Chris Burdick, I'd like to discuss one issue on the November 2nd of 2023. Need a motion for.
Motion for discussion?
We can discuss it.
Okay, I just wanted to procedurally.
Procedurally, motion for discussion.
Second, yeah, sure.
Thank you. Go ahead.
Okay, it's on page 1.
Why did you get a copy or is it pretty short?
Please make sure.
It's just one.
Everyone has it in
question.
their packet. Chris,
Oh,
what
yeah.
section? It's in your backup. What's your
It's
question?
on page 5, it's the third to the bottom paragraph. Begins with, Mr. Weiss, said for a city commission to be held in the head office.
Yeah, right, so it was.
Yeah.
Oh, last name, okay.
Okay, mine's different than yours.
Oh.
When is the November minutes and when is September?
This is
minutes?
so
November
wrong.
2nd.
This is so wrong, Chris.
Excuse me. You don't have support. Please proceed.
Okay. In there, it says the candidate should reside in the city for 6 months immediately preceding the date of the election. I thought we were talking about the district since this was a commissioner. And I don't know if anybody else has the same recollection.
I think this concern was over the fact that during redistricting years, that we ran into this problem since the city delayed the redistricting. It was the only city in the entire county that delayed the redistricting. They only approved the redistricting less than a month before filing.
No, I understand, and that's generally in the minutes. I'm just stating here, I think what my recollection was Mr. Weiss was talking about they had to reside in the district for 6 months. And then
So forgive me, Jackie, you weren't noticed yet. Richard, you're.
You're not, Richard. Go ahead.
Richard Weiss. I would have to check the tape and see what it says. I don't. It makes sense to me what Chris is saying, but I don't remember specifically.
May I be recognized?
Yes.
Thank you. I am, where it says Ms. Scott recommended removing the 6 months requirement for district races, but clarified the candidate must still reside in the city. I don't think that was my position at all. I was more in my discussion. I wanted to make sure that anyone running for district commission had to be in the city for the same length of time as the mayor and had to be in that district. And I think, Judy, you were arguing that you were making the same comment that you just made, that in the event we have redistricting, we don't want to shut somebody out because the districts change. And I think we were trying to build consensus, and I said, no, I'm not in favor of that, and we'll discuss it at this meeting. But this, to me, in writing, doesn't look what the discussion was.
Richard Weiss. Occurs to me, broader picture, that we spend an awful lot of time talking about what's in these minutes. There's two different ways of keeping minutes. One way is just sort of notice minutes, which is there was a discussion of this topic and the tape or the recording reflects what actually happened. What we're doing is spending an awful lot of time at the beginning of every one of our meetings, seeing whether whoever is doing these minutes has gotten it correct. And I'm going to suggest that we go to the other form of minutes because it's just, I mean, what we're doing is we're rediscussing the stuff as part of the minutes, which is not appropriate. The thing is, whatever happened at the meeting, happened at the meeting. And the only answer is not to discuss it really, it's to check them, to check the recording and say what was said. So to avoid all that, and I'm not sure, I know we have a professional service in the clerk's office, I'm not exactly sure. And I know Junior's trying to take some, and you're trying to take some, but the minutes are a problem every single meeting. So I'm going to suggest respectfully that we go to a different type of minute, so we don't have this discussion every single time. And that, the only thing that remains is the motion's made. I mean, the discussion is discussion, but motion is made, and we all agree on some word, we have a consensus. That's important, and that should be in the minutes. But if there's no consensus, if we don't come to a motion, then it's just conversation. And what I say, who's to say that what I say should be in the minutes, or what Jackie said should, so anyway, that's my suggestion. It's just.
Harrison.
I think for just the paragraph that Chris immediately brought up, which is the last one prior to eliciting public input. This is kind of a conclusion of the conversation, and also request that Attorney Bengal bring back an item based on this conversation. So in general, I totally agree with what you're saying. I think for the specifics of this, it is kind of important that we are asking for the city attorney to bring back something that reflects the will of the board. And I do think that at least the version that I have, and I really hope it's the same as everybody else's, the formatting was slightly different. I think the text is all the same, but I think that really does capture the conclusion we drew, which is that prior to running for office, so that it doesn't necessarily interfere with district boundaries, a candidate has to live in the district they're running for at the time of qualifying, and prior to that, 6 months has to live in the city. And to me, that's what I'm seeing here. So
Which I would adopt that. Chris, you were going to add something to it.
I agree with Richard completely. I think that's probably the better way to handle this.
I agree with Richard, and I disagree with what you said, so hopefully we can talk about that issue.
So
Make
just,
the motion.
Richard, does the clerk understand what we're talking about, the different types of minutes?
Correct, action minutes first,
Action minutes.
summary
It'll
minutes.
it'll say the line of typing. So for this, I think this is very important. And I think somebody should go back and the court and say what was said, but my recollection is the same, that it was just, we had some consensus on this. But we need to move on with the minutes, so I don't know if they're correct or not correct, so I guess we should defer approval of those minutes and approve the other ones.
You want a motion, Chris?
Yeah, ask Richard, will you make a motion to change the method in which we do minutes?
I do. I make the motion. to go to, what do you call them, action minutes?
Action minutes,
Action minutes as opposed to, sort of more verbatim.
summary minutes.
Summary.
Second.
Chair, just to be clear, so for the November minutes, we're not going to move with the November minutes until they're corrected, correct?
Correct.
All right. So then we'll go back with prototypes to correct the changes to the November minutes and bring to your next meeting. Moving forward, we will do the action meeting minutes moving forward.
Paul.
Thank you. Let me just share what I found that the Attorney General says minutes are one of the opinions. So the term minutes contemplates a brief summary or series of brief notes or memoranda reflecting the events of the meeting. Accordingly, a verbatim or notice, a verbatim transcript is not required. Just a brief summary or series of brief minutes.
So we have a motion and a second on the floor to go to action minutes.
Yeah, call the question. We have a motion, we have second. Clerk?
All in favor?
Aye.
All opposed?
So we go back to what we were doing. So we're deferring again approval of the minutes of November.
November
So
2nd.
what about, there's two sets of minutes on the.
Right,
Are we
so
ready to approve September? Finally?
I think, yes. So is there a motion to approve the September 7th?
So
First, word, second.
All in favor?
aye.
All opposed?
Clarification. What we were talking about briefly when Harrison brought that up. My recollection from the last meeting, I just want to make sure I am in order on this, that I didn't agree and wasn't ready to vote on that. And you said, okay, Jackie's not ready, we'll
All
bring
right,
it up.
well,
at the
we're
next
past that.
meeting."
We're
I'm
past
asking
that.
him a question.
You, excuse me, Jackie.
Am I correct or not?
We've already taken action, we're moving on with the agenda.
I can respond. I do remember the conversation. I don't think that the minutes reflect that we took any action.
Correct. Okay, good.
So
That's what I wanted to ask.
Chair, I just make a comment.
Yeah.
I think what occurred was Paul was going to draft the proposed wording, which he did. So Jeff, a little bit.
That's what I thought. I just wanted to make sure.
Okay, so now we're up to speakers. And I don't see Mary and phones.
Nor do I. Those will be my other personalities this evening. I just head back.
Okay. So the subject matter dealing with the supervisor of elections, and Harrison, do you want to start with that since you are a point person addressing it?
The two people I invited, are not.
I know, I will, Harrison, I'll try to answer all the questions. I just got off the phone with Mary, who just got back into town.
Oh.
Phone has a child, she just went home. So, sorry.
No worries. So again, we just had a couple of outstanding questions that related to elements of technical procedure. I believe that there was general will to discuss changing the way that we assign certain duties to the city clerk that are not actually performed by the city clerk, but are performed by the supervisor of elections office, and wanting to make sure that any changes that we are making are kind of copacetic with what actually happens at the supervisor's office when contracting with, when the city is contracting with the SOB.
Sure.
Trying to figure where we left off on that though. It was petitions, hand back over to you, Chair.
You want to go back? Okay. I think we had. Yeah,
I think one of the-
we got quite a few issues that like.
And then I have unsolicited advice.
Chris Bird, I think a couple of the issues were certifying the signatures on this. To mention process. I think the second is if we had a special election in order to have a vote on that citizen issue. That's what I remember. Yes.
All right, well, I'll talk a little more generally, and if there's any questions that are more granular. So pursuant to the special act, supervisor of elections. To the special act,
municipal elections happen in Broward County, March or November. The supervisor has discretion of whether or not to provide ballot access on any other dates, as we are now finding out fines for their special elections. So I can tell you that the current supervisor of elections use the March and November as the 2 times during the year that it depends on holding the elections. This special act doesn't require the supervisor to actually hold the elections. The city is always free to solicit, procure all sorts of machines and conduct their election. Requirements are the statutory one that the supervisor providing poll books for municipal election. And also the special act of canvassing rather than canvassing for canvases. But the actual holding of the elections is either pursuant to contract with the supervisor or held by the city itself. Having seen how certain cities hold elections in other counties in the state of Florida, I give you the unsolicited advice not to hold your own elections. But generally speaking, absent some extreme situation, yeah, elections are going to be held. Joe Scott is the supervisor, March. So in terms of the city, supervisor has the right to charge the verification. Supervisor currently charged with candidate petitions in the state races, county races, and for constitutional amendment petitions, 10 cents and 15 cents respectively per signature. I just had a conversation with Mary Hall, who confirmed that the supervisor, again, Joe Scott will also charge 10 to 15 cents to verify signatures on candidate petitions for municipal races, as well as the 15 cents for the like charter amendments and things like that are going on by citizen initiative. So that's again the current supervisor's position. We can speak to any supervisor in the future. So I would encourage you, as a piece of unsolicited advice, not to draft your charter along what the current supervisor is doing. Having worked for a previous supervisor of elections who provided ballot access during all sorts of times of the year. Again, just drafting your charter around what the current policy of a constitutional officer is a recipe for having to redo your charter later on unnecessarily. So to make it as broad as possible, under state law, it's generally the city clerk that is the qualifying officer for elections. Even if the supervisor is holding the elections, the city clerk is still the qualifying officer. The fact that the city clerk can still be the qualifying officer for purposes of verification of signatures is perfectly fine to have in your charter, provided you have language that says that it can also be contracted with the company. So providing you with both options, because I can't speak to some supervisor in the year 2100 deciding whether or not they're going to verify signatures. I'm sure we'll all be voting telepathically with that, so we won't need it. So that's my comment about that.
Thank you. So when we discussed this last time, it was my experience that the city clerks that certified stuff. Remember this stuff, and we had a whole conversation about it. So when we be covering ourselves, if we said the city clerk either directly or by so.
Yeah, the city clerk is still going to wind up being your qualifying officer, whether or not signatures or filing. Again, filing fees are easy and qualification fees are easy. They're delivered to the city clerk. Sometimes they get to be delivered to the supervisor of elections if by contract. The same thing with the signature, but it's still the city clerk. Yeah, but it's still the city clerk who is the person whose signature is on. These people are qualified as candidates. These people will be put onto the ballot, and it's still the city clerk that provides the supervisor the names of the qualified candidates and the ballot language for any questions.
And I think the question was more about the petitions for issues, since the clerk's office doesn't have access to the voter files. So therefore, how the ability, he would then have to contract with you because he doesn't have the access to the voter files.
Right.
And that was really the question that we were discussing, was more about the petition vote.
And the reality is, as we sit here in 2024, the supervisors are the ones who have access to these signatures. We don't have the traditional poll books that existed in the 1950s anymore. It's all on a computer. We have, just as we receive hundreds of thousands of vote by mail ballots whose signatures have to be verified in relatively short order as they're coming in, supervisor's office does have the staff and capabilities and equipment to verify these petitions as well. So just from a practical business standpoint, it makes sense to have this rather than have supervisor bring the clerk over and say, please sit at this computer and verify all of these thousands of petitions. And if your clerk will resign.
Can I ask the question?
Yes.
Okay, yeah. So, the statute with respect to constitutional amendment initiatives says that each supervisor shall post the actual cost for signature verification on his or her website, and may include his, right, et cetera. So the question is that, and it was on the supervisor's website. So the question is that, would verification of a municipality's signatures ever be different from that amount that's posted?
Okay,
Because
because this supervisor has taken the position, and I confirmed with Mary Hall just a few minutes ago on the phone, that for municipal questions and municipal candidates, signature verifications, Joe Scott is charging the same rate as he does for, other candidate petitions at the county, state, and federal level, as well as for constitutional amendment. So it depends on.
he says that.
He says that.
I believe that's in the statutory as far
It-
as.
it is.
because
Not
We
the-
pay the same, yeah, we pay the same that we pay Tallahassee for something that's statewide.
Everybody is charging the same rates. Sometimes they've changed. There have been times where the rates are different. But that's the going rate. I wouldn't put a rate in your charter.
No, but is it, I'm sorry, but is it fair to tie the amount that would be paid for verification to that statute?
I wouldn't. I would just say that that the fee, that, again, I don't even necessarily know why you would reference the fee in your charter, just that the clerk will directly, or the city via contract with the supervisor of elections shall have the signatures verified.
Because the consensus last time was that the city clerk would be out of it. So that it would be.
But again, the city clerk is still the qualifying officer at the end of the day. It's still the city clerk's signature that is affected. So supervisor can't qualify your municipal candidates. Supervisor can't say you have reached the appropriate number of petition signatures for an initiative on the ballot.
That's the only one, that's the only thing we're talking about.
Right, but I'm just saying that it's still your city clerk that is your qualifying officer. It's still the city clerk who makes is making that determination as to whether or not something has met the threshold. So the fact that the city clerk is being given the authority to contract out to perform part of that service, which is the verification of the number of signatures that are valid electors in the city of Fort Lauderdale, doesn't convert the supervisor into the one that says, put these people on the ballot, put this question on the ballot. The information goes back to the clerk saying, you have 5,000 candidates, or 5,000 petitions for candidate Smith and 3,800 petitions for this particular ballot initiative. And then city decides, is that sufficient under its charter or otherwise?
Okay. Is there a certificate that's issued, or is it simply a conveyance of?
I don't know. That's getting way too much the weeds. Go on my board, make sure they print out a nice certificate or something, but I think it's just a communication that says we have gotten X number of, verified signatures. This is the number that were rejected.
Because that affects how we refine, of course, what I draft.
So like all this. All of this. We eliminate. Or. Big, no. Wrong. Because. You remember the whole conversation?
Yeah.
The clerk's not capable of, the clerk is responsible. For stay in charter. Agenda, spot that eliminates the clerk, puts in the supervisor, needs to go back to where it was. That's what we could add contract.
I think that takes care of it because the clerk's office concern always like that position. Or it's not going to be extending the funds, so purchase holding. Purchasing the elections. So we contract directly with the supervisor of elections. We actually handle our elections. So I think it's just in that language.
And the current charter, is responsible clerk, which clerk should be, and clerk then can hire people to help him or her carry out those responsibilities, which we the supervisor. Or somebody else if they want to, but it's not practical.
Yeah.
Considering the signatures of voters are confidential and exempt under 119, I don't know who else really has.
Okay, so we need to change that.
The other question that we wanted to ask your office dealt with the amount of time prior to a special election meeting to be called. Most of them are vacancies. And if I'm not mistaken, part of I felt certain about this until I realized I did not know it for certain. On odd number of years, still require a March election because of a handful of cities that didn't move to November and January.
Yes, there are still some cities that will have elections in odd number of years to the chagrin of the supervisors.
Perfectly fair. And I think that, and this is a weird way of trying to phrase the question. Is it a special election if we are using a date that there is already an election taking place in Broward, even if it's not a regularly scheduled city for Lauderdale?
Anything that is not a regularly scheduled city of Fort Lauderdale election is a special election. The fact that it is a special election that happens to coincide with another countywide election that's happening. And again, the supervisor will do those absent some extraordinary circumstance in March and in November. And if you have any questions in terms of timing and ballot or timing and qualification periods for these kinds of special elections, today is a good day to ask me. I've been having to deal with it. City to the south, and memorized all the things. So any questions that you have on special elections, I have no idea how long that will stay into my head. So feel free.
Number of times.
Number of times.
So basically, I think the trigger, and I'm really sorry that I don't know which section this was in, but I'm pretty sure it was if there was 6 months until the next regularly scheduled election. Yes. So this is subsection 2.
Okay, this is the citizen initiatives.
Got it. So yeah, if no regular election is to be held within 6 months of such date, the city commission shall provide for a special election to be held not less than 45 days, more than 90 days from such date.
Okay, so a couple things. Is that just for citizen? Is that just for citizen initiatives, or is that for all?
The filing petitions must be filed within the Broward County Supervisor within 180 days, that section you're in.
Reading from actions on petitions. And there is such section.
By the way, I've been told that actually has a name called, they're called Romanettes. Don't ask me why I know that. I'm going on judge.
Are those Romans with a top on them?
But no, the little I is a Roman.
Oh,
The big I is just a Roman.
Action on petitions.
Yeah.
Yeah, got it.
So what was the language you were reading there, Captain?
So this was Roman 2, submission to electors. The vote of the electorate on a proposed referred ordinance. Yeah, so this was about the petition process or the initiative process.
So again, you can put whatever you want in your charter as to when you will be holding your elections. The supervisor of elections will be holding your elections in March and November. So at least this supervisor of elections. So I'm just letting you know that. So again, it's all well and good. And by the way, under state law, the city has the ability by ordinance, notwithstanding anything in a charter or special or general act, to change the date of any election to correspond with any countywide election that is otherwise occurring. So even if you have 60 days, 90 days, 120, 180, whatever, whether it's for initiative petitions or it's for candidates for filling a vacancy, the city commission has the absolute ability, without modifying your charter, to say this special election is going to happen in next March, this special election is happening in November. So given that that's the state of the law now and has been since, I think, 1995
Yeah,
on this particular point.
Bob Butterworth's Attorney General opinion.
So, you may want to give yourself as much, again, flexibility. And it goes back to, I guess, the first time that I was here, or the second time that I was here talking about these things generally, which is the more granular you get in your constitution, the more problems you will have because the exception to the rule will always come.
The concern is for a citizens petition where, where they're either trying to get pass an ordinance or repeal an ordinance. It's that
There may be a time
it is
issue.
possible that it's something important and urgent that the city commission is doing, unheard of, I know, that that the citizens don't like. And so it's possible that they're now waiting 2 years.
The most it would ever be is to a March or to a November, a March of any year or a November in a even numbered year. There's another alternative, and I know that I mentioned it like it was a dirty word the last time, which is mail ballot election. It is certainly not, the costs associated with a mail ballot election may be more significant than because you're mailing something out to everybody. It's not just people who have requested a vote by mail ballot, doing a mail ballot election. But the only thing that can go on mail ballot elections are questions. So
At the moment, we're talking about the citizens petition.
and
And it does concern me that they would have to wait. So at the most, the wait would be 6 months. Is that what you're
well,
saying?
what I'm saying is that you can certainly, if for some reason there is not a regularly scheduled countywide election that's happening in the period of time that's needed.
Such as August.
Yeah, such as all, again, what you can absolutely at that point say, if this is so urgent on a repeal of an ordinance that's gotten.
Well, so the thing is
signed.
that unless we put it into the charter, assuming that it's a repeal of an ordinance, we're forcing the city commission to do something. The city commission is not going to not going to feel like it's urgent.
Right.
It's going to be the petitioners who feel like it's urgent to correct something or to repeal something. And unless we put a time frame in here,
Well, you might be able to put a time, Richard, and I'm sorry to interrupt, but you might be able to put a time frame in there that says to some extent that if there's not a countywide election occurring within the next blank days, that the citizen initiative petition will be done through a mail ballot election in accordance with Florida election code.
so we
So,
don't have to say it's a mail ballot. I mean, right now it says, what, 45 or between 45 and 60 days, is that what we have right now?
Less than 45, no more than 60.
And the state commission can decide how they want to do that.
well, and I need to double check the mail ballot election statute in terms of what the notice requirement is before, how much notice you have to give for a mail ballot election. So give me one moment.
So what would be the longest time that something would be sitting around?
For
Let's
a,
assume that people filed the petition the day after an election in March. So would the longest period be until November, or it could be a year and a half to the following year because you don't
it
have.
could be,
elections
it could
every
be a
year.
year to the following March.
Yeah, could be.
That's a long.
That's the longest it would be because we hold those. Trying to find,
So you hold an election in Broward every March, no matter what?
no, it's only if we have, we have a whole slew of elections that are supposed to be happening in March of 2024.
Right.
If only the incumbents qualify and nobody's showing up to vote, well, other than it's a presidential preference primary, but let's say it was the 2022. And we've had scenarios where, there was an election that was gonna happen and nobody came.
So the question for the group is whether we feel like we should mandate that these things get put on the ballot between 45 and 60 days, or whether we're comfortable saying that citizens petitions would go on the following, the next general election, the way they call it is, Harrison, they say it's a special election in conjunction with.
The countywide election, and I wouldn't say general election because the next election might be
So
that
that's
March
suggested
municipal.
for the group.
Makes sense because the system
And it
is
goes
already in
back
place and
to what
that's
we've discussed in the past. every month about trying to be consistent with more state law and less, you
So
know,
how do you feel about
control
that?
here.
How do people feel about leaving it that a petition might have to go, a year, sitting around a year versus mandating that it go on a ballot within a certain period?
Harrison?
I mean, Harrison, my personal opinion on this would be, I think that having a March election every year, a November election every other year, August countywide elections, the same every other year November's are. It just makes the most sense to say it's delayed until the next one. And even if, in the worst case scenario, if somebody has a petition that is all but ready to be verified and they miss the deadline of this upcoming March, I mean, I don't know that anyone's getting 10,000 signatures or I forget the number that we suggested overnight.
And
This
one
is
other-
gonna be a process.
One other thing for that, Harrison, is that if you, and Paul, when you look at the constitutional amendment petition process, there are deadlines. If you fail to meet, it is bumped to the next. I mean, obviously, it's a little different at a city level where you're allowing the residents to, you know, compel the enacting of an ordinance or repeal of an ordinance rather than the broader constitutional amendments.
What
But
is
that's
a
an issue.
special election call?
I'm sorry.
What's a special election cost the city?
A special election.
A special election not in conjunction with a regular election.
Oh, wow. The city of Fort Lauderdale, I mean, again, if the city of Fort Lauderdale, and again, the current supervisor is not giving out special election dates, standalone special election dates for municipalities, that, again, absent extraordinary circumstances. So that really wouldn't happen.
Well, they would have to hold it, if they had some charter, they would have to hold it themselves, they would have to contract with one of these private companies that would do it.
There's no private companies that you can contract with to hold the election.
They would hire.
You'd be spending hundreds of thousands of dollars buying election equipment, having individuals trained on how to run the machines. I mean, you're talking about potentially in a city like Fort Lauderdale, just to have the machines on, I don't know, first of all, I don't even know anybody that leases these machines out because
You contract out, I've seen this.
Okay, yeah.
It's not easy or pleasant, but you contract with the company, and the company brings in the machines, and they bring in the people who operate the machines and all of that. Now, I'm not saying it's desirable
yeah,
at
I
all.
have no idea how much they would cost. I've never heard of it personally, and I certainly have never heard of it in the state of Florida.
And actually, David had pulled up some numbers for us in the past as to,
What is it?
yeah. So it was the clerk's office, they could make that call and get those numbers. But they have done studies
Mary
in the
volunteered.
past.
I'll go get her.
Oh, thanks.
Oh, she,
So Harrison, you would feel like that it's not necessary to mandate the shorter term, you would have it in conjunction with the next regular election.
Right, and the one other point that I had that was towards this, which again, memories are coming back to me in waves. It's been a long month. What is the deadline prior to the date of election for something to be submitted to be verified for the ballot?
correct, because that was gonna be my next question. There is different filing date than a candidate's filing date because of the time of the certification.
Now, the question, are you talking about the signatures? Or are
No.
you talking about the ballot question itself to be able to be put onto a ballot?
The second.
Okay. So for example, the supervisor for the August election generally asks for cities to provide any kind of, and we're required of the county, not the cities, but the county was required to provide its ballot question for 2018 and also for 2020 by the middle of May. But again, he's not providing ballot access to municipalities in August as a general practice. For November, we were required to provide it by August. There's a reason for this, which is the ballot design process is not a simple process because it has to be, they're programmed. We need to have all ballot questions in English, Spanish, and Creole for the ballot. That's required of anybody submitting any question. The supervisor, because we're operating under, in fact, the whole state is operating under various court orders associated with multilingual ballots. The programming time and in connection with if it's either a March presidential preference primary, where you're putting a municipal question on, or a November general election, supervisor is required to mail out ballots 45 days before to all overseas voters. So in early November, that pushes you back to the middle of September. And we need that, at least that 30+ day period to help figure out ballot design. Otherwise, things are a mess.
Which was the problem, like the past, we had to by city ordinance to change some election dates when we have primaries. Because of the overseas ballot, the changes in the law dealing with the overseas ballots.
Chris, how do you feel about this, about having a 45-day versus 45, 60-day deadline versus just having it go in the next general election?
I agree with Harrison. I think it makes a lot more sense economically as well as procedurally. But what I'm hearing is we couldn't do it any other way other than,
I mean, you could, but it could be
And
very
Richard, it
expensive.
brings back to what we keep on saying, consistency.
So you think that putting it on the next general election, not a special election? Jackie, what do you think?
I agree with Harrison.
Okay.
We've already got a system in place. We're
I make a motion-
reinventing the wheel.
Make a
for those.
motion that we amend language that call it previously to eliminate this. 60-day Have it go on the next regularly scheduled. What is it?
So before you,
Special general election.
before you, I guess, before you make that motion, if you're choosing to put it on at the time of a regular city. If you're choosing to put it on the ballot at a time where the city of Fort Lauderdale is otherwise holding its election because there's a countywide election occurring, like for the November generals, then
Mary Paul.
Mary Collins, she's deputy supervisor of elections.
Finish your thought.
So, if you're putting it on in the November election, your costs are incremental because because the supervisor is holding an election everywhere in the county. If for some reason you're choosing to put it on in March, there is not going to be any other election in March. And then you're gonna be dealing with, I mean, what was the charge per precinct when we had standalones? Couple thousand? Thousands of per precinct.
And how many precincts are there?
355.
It just in Fort Lauderdale.
Just, okay, in Fort Lauderdale, I think they have like 60.
Yes, we have figured in the past, it's about $300,000 that
Yeah.
we're looking at.
Okay. Yeah.
So given that,
What's that?
do you,
I am happy to second your motion.
but given what Nate is saying, do we want to even limit it further and say the next general or special election, which is going to be held in the city of Fort Lauderdale? Because that could extend the thing even more, right?
That you're now moving,
Now
that
we could
technically,
move
if somebody
2 years,
submitted
right?
all their petitions the day after a November election, well, this petition is not gonna have a question heard by the voters until the next general election for 2 years.
Which brings it by being in the charter, enough knowledge and notice.
So are you okay
Or
with
you
that?
can, again, you could also have in there the escape valve of something like the city commission may, in its discretion, elect to have it as a mail ballot election before the next one.
Yeah, that's good.
I just throw that out there as
Mail
ideas.
ballot election costs in the city of Fort Lauderdale.
Well, be mailing to every
Yeah,
voter.
every voter.
Couple hundred.
Country, yeah, it's cheap, it's gonna be cheaper than a.
Because one of the things I was thinking was leave it so that we're not spending city money, but give the option to the petitioners. If they want to pay for
the
it.
election. I've
don't
seen
pay
that.
the election. I mean, if it's an important enough issue. Like that,
No,
as an option, not that they're
we've
paying for
heard
it,
that before.
not that they're gonna have to pay for it, but it gives them an option to pay for it if they want.
And then the other question is, for constitutional amendments, for example, who are you charging the 10 or 15 cents, or who are you charging the 15 cents signature verification to? Isn't it the
It's
organization?
the organization who give
Organization.
us the petition.
So your organization that is putting the petition on,
Committee would be the petition committee.
yeah,
So do we want to give that option or you don't?
talking about the option of paying for an entire election.
Talking about
The
having,
mail election.
giving the, putting it on the next ballot where the city of Fort Lauderdale is having an election, or at the option of the petitioners at their expense, it can go on as.
mail ballot.
So
I think that's very.
what do we lose by giving it?
They'll lose everything.
You don't lose anything because you're giving them the option to decide. It's in the charter. They have advanced knowledge and they can make a determination as to their
I don't know
timeline
that
to.
anybody's ever gonna do it, but it does give them, you know, it's a major.
And again, Richard,
Yeah, I mean, I think the option is good. I don't think it's ever gonna be used. I think we talk about a lot of things that
at
are never
at
gonna
the end
happen.
of the day,
It's true, but
all we're doing
It's
is
good.
making recommendations to the city commission, and it's the city commission that votes whether or not they're going to take it to the public vote anyhow. So we can have this discussion, but still, we're not the determining factor anyhow of what's going on the ballot for the charter changes. So there,
Well, I'm happy to go with this. People
we can
think.
put the discussion
we should-
forward and make that
we should
recommendation
do
for
it, give them an
consideration.
option, then I'm happy to do that. If people think it's just too expensive and it sounds silly, then I won't. So we have a consensus to put it in and let the commission do what they want with it. I think. I don't think you lose, I don't think the petitioners lose anything. I don't think it's objectionable. And if nobody ever uses it in 100 years, okay, so.
Can I ask a question for clarification?
Yes.
The commissioner's option or for the committee to opt?
No.
Petitioner,
The
petitioner's
petitioner would have the option to either do A or do B.
Commissioner or committee?
Yeah,
So I mean, you could think of a scenario, which is actually happening today now, where it's something, let's say, dealing with like some well-funded thing like casino gambling or prohibiting it or wanting it, or some, I don't know, some other thing where the petition, there might be some financial backers and they may want to do it. I don't know.
although they do hold many more elections in Miami-Dade
Once a
County. The joke is if it's a Tuesday, it's election day in Miami-Dade County.
And we did do the special election with the slot campaign here in 2005. So, you know, and certainly they would have been happy to pay. So if you leave the choice,
Yeah, I don't
They
feel
have
strongly
choice.
about it, but that's our consensus, Paul, let's draft it up that way, and the commission can do whatever they like with it. Including strike it out. With one voter ready to strike it out, the peanut gallery.
did you decide yes or no?
We can put it in as an option, yes.
So there wasn't.
No.
There was a motion, so are you gonna follow through on the motion or was it withdrawn or just like consensus? is
He was about
direction?
halfway through the vote and I
Halfway through it, I
interrupted him.
So is it consensus giving me direction?
Yeah.
Oh, okay.
There's let's do this so it shows that there's a motion to amend the language in the referendum section to say that elections on referendums will be held in conjunction with
City's general election.
City general elections, the next city general election, unless at the petitioner's expense, they opt to pay for a special,
A mail
a
ballot.
mail
Mail
ballot.
ballot.
Second.
All in favor?
Aye.
All opposed?
Harrison, before you move on to your next topic, is it okay if I give a piece of completely unsolicited advice from something that I heard earlier in the meeting? So you were talking about the residency issues. I was just reading several cases because they relate to something I'm dealing with in another part of the county. Where you did have during the redistricting years, individuals who had lived in the city let's say they lived in District 1 for the last 25 years. And a boundary, and shortly before the qualifying period for an election, the boundary moved and now they're in District 2. If you have language in there that says you must be in the district for the 6 months immediately preceding the start of qualifying, that person is now not eligible to run anywhere because they haven't lived in District 2 long enough to qualify, and they can't run in District 1 because they no longer live in District 1. So you basically are saying that this person can't be a candidate anywhere. I have seen a number, and if you think about it, during reapportionment years at the state level, people can get signatures anywhere in the state. You can live wherever the heck you want. You just need to be where you're supposed to be at the time of taking office.
Right.
So I have seen city charters, including several in Broward County and also Miami-Dade County, that specifically put a carve out for in any year of redistricting. The 6 months is combined in the district that they were in before, plus the time of the district that they're in now. So in
That's a good
essence,
idea.
so I just bring that to you as completely unsolicited policy advice. And I don't make policy, but I just bring it to you as a potential option if you want to think about that.
So
Since
back
you're
to
talking
the
about
issue
these
for the
issues.
minutes, what do we want to do about this? Do we want to say you have to live in the district 6 months unless it's a year of reapportionment? Or you want to just leave it 6 months or how do we?
I think it's very important to give the consideration of the flexibility of redistricting years. You go through in the state level, we have it, in state legislative races, the same thing. And again, I think whatever the most we can do consistent with state law and state policy is to our benefit.
I guess the danger is that you could have someone who lived in the district for 1 day.
But they're
how
still
far
in
is
the city.
reapportionment done in ahead
But you're-
of?
They're still a resident in the city.
That's
They
true.
still have to be a resident of the city.
How far ahead does reapportionment go?
Well, this is the issue. This was the only city that delayed the submittal to the county to just weeks before filing. And it was a problem for their office.
Very close.
All the others were done basically December, January. They waited till May. So it created this unique situation. And it really had major impact in them in being able to do their precincts, because I got phone calls constantly.
As part of my.
And I
as
think
no
the
power.
ballot.
That's correct.
To complete the
Complete the
ballot
ballot.
also.
And I had put in writing to the city attorney and the city clerk that previous spring saying, hey, guys, this is a problem that you need to address, and it was ignored. So it became a serious situation for them.
All right, so we have consensus that we want to take care of the
Harrison, you-
reapportionment there, Harrison?
I have one, and this is going to sound very picky, but it is not unprecedented. 2016 is it a redistricting year just by merit of the fact that the maps have changed? Because that is the one usually ending in 2. However, we have definitely seen boundaries change in the interim. That could be triggered by any number of things, lawsuits, et cetera. So do we want to restrict the language to say redistricting year, which kind of implies once every 10 years, there's a session?
It would just be any year in which there has been redistricting, provides you that.
Well, we're going to go down this rabbit hole. What if there was redistricting, and it didn't affect the person's district, but they just moved to the other district just before qualifying?
Well, I mean, we had in the city of Hollywood, when Jamie was
Yeah.
the city attorney there, where they combined 2 districts into one.
But somebody might not even be affected by the reapportionment and take advantage of this provision. I mean, if we're going down this route.
Jackie?
Yeah, I feel strongly about this as it relates to the length of time. I think that anyone that's going to run in a district, with the exception of the years that we redistrict, they need to live in that district 6 months before qualifying. And qualifying is the time in which they fill out their application, right?
Well, it's when they
Because
actually.
otherwise, what you're gonna have is you're gonna have political consultants and people that run campaigns telling people, come over here, you can run here, this is a weak candidate, you only have to be, here. I don't want any part of that.
You know,
I don't think it's fair.
You know what you could do, and
I don't
Richard, to your point, you could put it to the charter, if you don't want to have it as broad as, okay, someone is going to game the system and take advantage. But you could say that any individual that's filing that has lived, whose address has been impacted by redistricting, you count the 6 months that they were in District 1 as towards the time that they're in District 2, because they have to be a resident of District 2 at the time of qualifying. Because that won't allow anyone to game the system. I'm living at 1 Main Street and I've been in District 1 for the last 20 years, and all of a sudden 1 Main Street, 3 months before the election is moved into District 2.
Right.
I'm not gaming the system. I can, but I
I
now
know
have to
everybody
run
trying to game
District
the
2.
system in the city of Fort Lauderdale. Don't do whatever.
But I think that probably solves it, and you may want to bang it around for another, I don't know.
I like the idea of exceptions when there is redistricting.
That impacts,
It
it
impacts-
impacts an individual.
Yeah, I don't want to throw crap that you're talking about. That's
You know,
just my
you
personal
had
preference. I think
situation,
that we need
you
to-
had
I'm sorry,
situation,
Judy, did you interrupt me or I interrupt you?
you had situation where the countywide voters voted for redistricting to be done by an educational institution or a higher institution, what's the exact
It's,
language?
it's a, I don't know the exact language, but it is a
Four-year public.
four-year
public
public,
college.
yeah.
And the voters countywide voted for it, thinking that that's going to be the process. However, the city chose not to use that process initially and wasted 4 months by having a law firm look at it until the other commissioners all said, wait a second, we don't do that. And then they needed time to go find an educational, did not want to piggyback off the county, which had already done it. So it delayed everything and things kept them shifted. So it becomes a situation that I think the more we can adopt the language in the other forms of government, and the less that we have to do, keeps everything, on a steady pace.
But I agree with Jackie. Yeah, we have to make that exception, but I also agree if the person who is living in the district has been affected by redistricting, then he gets the buy, but not everybody.
Right,
Okay.
yes, so because.
Yes, Savai, give me that scenario, Chris. Wait, describe that to me.
Okay, the person who's living in the district.
I'm living in District 1.
Right, and it's been redistricted and you're no longer in District 1. That means you can run in the new district or whatever district. The difference is, before, if it was just broad, anybody in the city of Fort Lauderdale during redistricting could then run for any other district and wouldn't have to live in that district.
So,
for 6
so
months.
if I'm living in District 1 and we redistrict.
Yeah.
And I want to run in District 2 and I'm there, I just go ahead and get to do
No.
it right then.
No, you're only allowed to waive the system of requirement if you're affected by the redistricting.
meaning your existing.
Oh, you were already going to run. You're already running.
No,
What I'm
that's
saying
not
is
what I'm saying.
that if I live in this district, I lived there for 20 years.
Right.
And all of a sudden I'm in another district based upon reapportionment, right? I'm affected by the reapportionment. So therefore I get to take advantage of this exception. But on the other hand, if I live here and there's reapportionment and it doesn't affect the district line, I don't get to take advantage of it. It has to affect you.
Okay, so in that scenario, suddenly the district changes, and so the day of qualifying, I go, I'll just go ahead and run for this because I've lived here for 6 months.
No, what it would be is, let's say you're living at 1 Main Street that is in District 1.
Mhm.
And as a result of a boundary change, you're no longer in District 1, you're in District 2.
Right,
You are now a resident of District 2. So you count the fact that you've been living at the same address. You can't move to a new address to start gaming the system. In essence, the boundary moved around you, so you're able to run where your boundary now
for the
is.
district you were in.
No, for the district
Yeah.
you're currently in, not your
New
old district.
New
And
district.
that can happen the day of qualifying.
Well, I mean, the fact is that the boundary is not gonna,
Happen today.
the boundaries can't be happening the day of qualifying.
Right.
Yes.
That's not possible.
I don't know.
I think.
I'm trying to, there's
I
so,
think it's pretty logical, so maybe we're not doing. a good
That's
job.
okay.
No, I'm sorry. Maybe we're not doing a good job explaining. So if you live in a district and your house, your residence is affected by the district change,
I get that.
you get to come under the exception because there's no way you could have lived in, you would have to move your house and live in it.
Right.
Otherwise, there's a 6-month requirement. The only time that you have this little exception is whether.
When there's redistricting.
Yeah, in essence, the boundary moves around your house.
Your house.
Gotcha.
And it seems to grandfather into the actual property as opposed to the person living in it.
That's exactly
Right, so that address, even though it was District 1 6 months ago, well, for the last 6 months, it's been District 2 because now it's District 3.
Correct.
It's a very narrow exception.
Fine,
You're
never
affected by redistricting.
And you still have to live there for 6 months
Gotcha.
before qualifying.
And I will tell you, I know that you just said that this likely never happened. There are two
I'm sure.
third district court of appeal cases where this exact same thing has happened. And because of the language in the charter, one way versus the other way, the candidate was either able to be qualified. Because the language in the charter that was an issue said that you must be a resident in the district for the 6 months immediately preceding qualifying. Which meant it meant the city commission could approve a boundary change just to hurt the person potentially. And that was actually the allegation that the individual made in the
So I'm
lawsuit.
gonna make a motion, I'm sorry. That we amend the section dealing with 6-month residency to put in an exception where a person's residence is affected by a ridiculous district, very narrow exception.
And they still have to be a resident of the
Yeah,
city.
Still have to be versus a citizen, they have to live in the prior district for 6 months.
Right.
Guys, well. Got it?
Well, I also think
I made some motions.
Second.
Birdie. All approved, all in favor?
Aye.
All.
And Paul, I think that when you bring that the councilwoman was removed from office and arrested on felony charges for going, in order to make that sudden requirement, went to the driver's license bureau and put a fake address on the driver's license so that they could claim that they had residency when they knowingly did not have residency at that address. And that was a 3rd-degree felony charge, and she's been arrested and removed from office. So you could pull that up. So we have to have some backup so that we can educate people
Okay.
about the importance of the residency and how to use qualify for residency. I think that
Anything else?
be aware. Chris?
Yeah, I just wanted to make sure on this motion, we're talking about section 4.05 of the charter.
Yes.
It's in our materials for the meeting, it's the last page.
Yeah, you're right.
405.
Yeah, it was at a previous meeting, that you put in place there.
303.
And
Yes.
permanent residency for city.
Yeah, 405, those are the same. I think it's 303.
Okay,
I think it's
303.
303.
I just want to make sure the record is clear what we're talking.
303.
Can I ask a question? What was that all about with them? It's like, what are we talking about now?
We're
You
talking
told
about,
about some case. What does that have to do with this?
it has to do with everything because we're talking about declaration of residency. And when you have to provide
So what's that gonna help us with? Make sure their driver's license are accurate?
your voter registration and driver's license, have to be declaring your residency, it has to be legal in order to qualify.
So can you have a driver's license that's different than where you vote? Or can you, never mind, we'll talk about it later.
Is that what you want me to bring back, the discussion on that section?
Well, I just wanted to include that because I think that's all important when people file for the office and they're showing their residency, all this matters.
Okay, Nate, do you have anything else that you would like? to talk about?
Unless anybody has any questions.
Okay, Mary, what about you? Is there anything, you're just here to answer questions?
That's it.
One of the other questions we had from them too was, I think you brought up about storage of space. There was something about space and
Very
holding
possible.
the
My memory is not
petitions
what it
and the
used to be.
records.
Oh, I did, okay, yeah, okay. I'm trying to remember what my question was though. I think it was just a question generally of who, if not the city clerk, is required to, be the custodian of records and for how long. Just again, so we're not saddling the city clerk's office with something that they wouldn't be doing, these could be keeping petitions from the 1980s. Yeah.
Well, the petition signatures after they've been verified by the supervisor's office and you give them the number, you're sending back the originals to them to the city, or you hold it?
No, we're holding.
Oh,
We'll hold them. They're our custody there. And then we'll do the retention for them. And then we will get rid of them when the retention time is over.
Which I believe for municipals is 12 months.
Yeah, but right now we're doing everything for 24. So that there's 22. Well, no, we rounded up to 24. Yeah.
You round up.
Around.
Okay.
So that there's no differences in the municipal versus a state or constitutional amendment.
And I would encourage you not to put that in your charter because that is what the office is doing currently, and who knows, 50 years from now.
They'll change it. They'll change it next year.
Yes, Paul.
Is there any additional charge beyond the per signature verification?
You know. We're just gonna check, we're gonna charge for verification, that's it. And then we'll certify and give it to whoever, the city clerk, the group, whoever is in charge of that petition.
And that follows on the question I was asking before, so there's a
Certification.
certification that the supervisor issues.
Yes.
Oh. That I was asking.
And let me ask one last question. When you do a petition or initiative, there is no guarantee with early voting. So early voting only takes place during the November elections versus the March elections, correct?
Unless it's a PPP, unless it's a presidential preference. But for a municipality, they never want the early voting because it's so expensive. So cities always opt out for early voting.
Yeah, but by mail.
Right,
But they don't have an early voting,
Right. No early.
unlike November elections.
I was just gonna suggest that we move back, unless we have more questions. We go back.
Can I trouble you, Nathaniel, to Mr. Quist? Could you share with Ms. Hall the proposal as 2.15 and see if what I put in there?
Yeah, whatever you have the final, I know that there's some more discussion that has happened, so whatever the final is, just shoot it on over. I mean, I never disagree with Karen, so I'll send it to her.
Come on, Judy, you know what we're talking about. We'll
figure
fight
it out.
about it,
Okay,
and then,
so our next topic is to discuss 3.15, and once we get it to the point where we think we're done with it, then we'll everybody look at it and see whether they.
Our pleasure to help.
Okay, I suggest that before that we go through what Paul's drafted in 3.15 and maybe try to finalize this.
Where do I send my inputs?
Come in, please.
All right, so I can give you, Manager, like I think the summary of what I put on.
Maybe you don't have this.
So the changes that you see are those that I made following your last meeting. Otherwise, as you recall, this is a proposed replacement of the existing 3.15. That's why not everything is underlined. The entire section is. So in A1,
Well, I just think that the whole section is new, that it should all be underlined, because otherwise I think it's.
a little bit what I wanted to do is show you the changes from our last discussion. I thought that made sense.
Okay.
Okay, so in A1, I added a couple of exceptions to the petition, the initiative process based on Florida statutes, and I explained them in the note in the margin. So changing the actual zoning map designation of parcel or parcels of land, and changing the actual list of permitted conditional uses within the zoning category and accepting them from the process based on the statute that are in the law. I deleted committee members being responsible for circulating the petition as you requested. I took the city clerk out of the verification process, but I'll be putting it back in to some extent based on our discussion today. In C, the city attorney has 30 days to make a finding of legal sufficiency. If insufficient, the committee has 30 days to submit a redraft. City attorney then has 30 days to find it legally sufficient or legally insufficient.
I think that if the city attorney is going to find it insufficient, you should tell them what's wrong with it. I don't think that we should play hide and
Both,
baby here.
both times?
Anytime with submit to the city attorney as as sort of a public service to make sure that it's legally sufficient, so people don't do all this work and then have.
Which is what we directed the last time.
And I think
We
that-
already had consensus on that,
But I think the city attorney, if you reject something, you should,
correct?
or he or she should tell them what's wrong with what's wrong with it. Program. Let's see.
All right, and E. I made the required number of signed petitions to be.
What's the question?
I have a question. If the city clerk doesn't supply the appropriate petitions, can the citizen, are you suggesting that the citizens committee, are we thinking that the citizens committee can come up with their own petition forms? Because it says the city clerk may at the committee's request, which implies that maybe the committee doesn't request it, and then the question is what happens. But should we mandate that the city clerk issue the forms, or should the petitioners committee have the ability to, on one hand, by having the city clerk issue the forms, they're gonna be right. Otherwise, you could end up with some forms that maybe are not.
Well, the form,
Well, I was going to say off of that, if the petitioner is submitting to the city attorney anyhow, the approval, then
But the
Why are we
petition,
having
but
all the
timeframe with this?
the amendment to the charter might be legally sufficient, but the petition form could have some.
yeah, no, that's, I'm agreeing with
Yeah.
you, is why would we have that?
the form is also subject to the city attorney approval, but that's in E.
Yeah, but it says the city clerk may. And
May,
Question is whether the city clerk shall issue the forms, whether that
I
makes it
could,
clear.
I could change the order, could put the, I could put the city clerk shall, but then move the city attorney's approval back up to that into D. Or the Congress.
Maybe we should have the petitioners committee submit a petition, the language and a petition form. And let the city attorney review them both and approve them both. And be a two-step process. One step.
one step.
One step. which is
One
you
step
submit the
process.
language
Oh, before, okay.
and you submit the petition form. And the city attorney then can review them. I just don't like the idea of people going through so much work and then get kicked out by the city. It's not fair.
So how do we go?
What do you think? What do you think? about petition?
Peterson?
I'm trying to think if there's an easy go-to that's similar to this, because every time that a candidate files that petition, I'm guessing this is a form designed by the state, because they always
Yes.
exactly the same every time you see it.
It's a form that we download from the state.
And I'm assuming that the city clerk should basically have something that is the boilerplate thing that people sign. And again, the only thing that's going to be different is the language that the committee is submitting for what they want people to be affirming when they sign. And maybe it's just as simple as the fact that the title at the top of it, you're not signing for a candidate via office, but initiative as, I'm not gonna come up with great language, so,
Ballot edition.
Chris?
Yeah, but
just to the nature of what it actually says.
I think that's what Richard's saying, is we should submit both the ordinance itself as well as the.
On the petition
on the
form.
petition form. So there's no problem, such as we talked about last time.
Well, you have it in here. I think you just have the city attorney in two separate spaces. You have it in yeah, I think that you have it in C, and you also have it in Roman.
C is for the ordinance.
petitions. I think that the city attorney should approve both the language and the petition form as a sort of a public service, and if there's a problem, he or she should let the petitioners know what the problem is and show them how to correct it. And they should be able to. That's what.
Jackie?
As a form, it would seem to me, and maybe this is the way it works, there should be one document that anybody can use. It should be standardized, and the city should say, this is our recognized form that must be used. And you're knocking that whole out versus people.
Jackie, but on that form, you have to put the summary of the petition, and
Sure.
that has to be approved.
I got that, but I just want to make sure, do we currently have a form, Greg, that basically is, do you know, anybody know? Whether or not you're gonna do a petition, and this is exactly the form. to use?
Anthony may know
Because we
the answer
should.
better. Anthony?
I don't, I've never seen a standardized form like that.
Paul?
The petition form has to have a place for signatures, but also it requires that the full text of the ordinance be attached.
Yeah, I get it. I mean, I guess I think in terms of everything we do in real estate that has approved forms, you use it, you fill it out, and you know it's right, and that's the way you have to do it. We don't? Okay. That might be a help to the people.
Well, why don't we say that the petition form shall be on a form,
Standardized.
a form approved by the city clerk, or developed by the city clerk. And that way he or she will do it once. It'll be part of the city documents. And if people want to use it, then it's like a fill in the blank.
Right.
You put in the text of the summary of the ordinance, you attach the actual ordinance to it. Let's do that.
It's gonna take a lot of them.
Let's do that.
Want to move forward with that?
Yeah, let's move to have the city attorney review both the petition and the actual ordinance language. And have this mandate that the city clerk develop a petition form to be used for circulation.
Well, I think the city attorney versus city clerk should be creating the form. But
Okay, it doesn't matter. I just think it should come from the city.
I think it's
I
two
guess
separate
it's distributed
issues.
by the city clerk.
Just say the city develops it and then say.
We should really want to develop the form.
The city as a whole. I mean, do we have to tell the city how to operate from the standpoint of who should create a legal form? I would think that would be from the
Well,
city
that-
attorney's office. I don't think it
That's
needs to
going
be
to
the
come from
charter.
the city attorney's office, so it doesn't matter.
And then the city clerk has a form that's
So Richard, your motions,
Second.
second,
Yeah, so it's seconded.
So I'm ready to second.
Yeah.
If it's.
call the question.
All in favor?
Aye.
All opposed?
Yeah, let's keep going on this.
So in E, I wasn't certain what to do on this because there was also discussion about whether it should be 1%. What I did was model this after the Florida Constitution, Article 11, Section 3, which is 8%. So you may want to discuss that further.
We did last time I had a motion.
Yeah, it was in, I saw that in the minutes
There
too.
was motion 1%.
1% or the number,
Or the minimum required by
by
state
state.
law.
Yeah.
So the concept for a constitutional
I-
amendment is 8%.
I don't know if that's. When I called up to the state, they said 1%, but
And maybe,
I think if we just, instead of putting in numbers, because the legislature can change from year to year, if we just make it consistent with whatever the.
Which
pending
section are we
state
talking
law,
about?
Keeps it simple and clean.
Maybe it won't be.
Which
other
section?
submissions.
No, I have it in front, which, just give me the number.
It's E live. 315.
Roman numeral 1.
Okay, can we just go a little bit slower? The procedure for filing of the petitions. Committee's payment to the Broward supervisor elections, are they gonna pay the supervisor elections, or are we back to?
Oh, no, we're up on top of petitions, number of signatures.
Oh, okay, where is it? Oh, yeah, got it. Yeah,
so I use the amount that's in the Constitution for initiative, for constitutional amendment initiatives. And it's actually, it's a little more complicated. It's signed by a number of electors in each of 1/2 of the congressional districts of the state and of the state as a whole,
No, keep
equal
it,
to 8% of the votes cast in such a.
but what we discussed at the last meeting was keep it consistent with whatever the state law is, so that every time they change the law, we don't have to change the charter. So if we keep it simple and consistent.
But Paul raised an interesting point. If there's different percentages for different types of, ballots, we should keep it, make sure we identify the right one, because the constitutional amendment, at 8% is different than what we had previously looked at, which was 1%.
And I didn't find that. I'll have to look further. I didn't find that. I'm not sure where that is.
Again, it goes back that I don't think we should be putting the percentage in, so just take the language if you want, do it with constitutional amendment language, but
But do we want to, well, I think we need to do a little more research to see if there was a higher threshold for constitutional amendments versus other.
On this one, Judy, I sort of disagree with you. I think that just for clarity, because if you're referring to something else with a number, there could be several sections, it could be, I sort of feel like you should just put a number in and people. Which, if it's a percentage, it's gonna fluctuate with the population, so it's not gonna get stale. So I feel like we should just put a number, unless there's a reason not to.
my reasons it could be changing from legislative year to legislative year.
No, but that's why I'm saying that if you put a number in, like a city, whatever, 1%, whatever the number is, it's never, it'll always be fresh. It'll never be changed. It'll never be affected by the legislature. But.
So,
I'm
yeah.
over it. I would just.
Let's just re-verify that one section and bring that back. Because the state office said 1%, and that's where we came up
I'm,
with 1%.
to me, I'm fine with putting in 1%. I just am, what I'm concerned about is referring to a very large section of the Florida statutes that deal with constitutional amendments, and I think it just.
Yeah, so let's just bring it back and just re-verify, and then we can.
So it's,
See what's fair.
so this is gonna be, we'll come back on that.
I'd also like, when we talk about this, to have an example of how many people voted in the last regular election. So as we're picking a percentage point, we really have a realistic idea of how many voters.
We
Well,
have
we
that,
have that.
132,766.
So you did 1,300, if you did 1%.
Yes.
Yeah, we should revisit that. Thanks.
All right, so E1, we're gonna come back to, yeah. Okay. So if I E2,
Okay,
we're
so.
gonna change that, right?
Yes. So I'm gonna say that I made, at your request, a petition by your subject to city attorney's approval, and that'll be further revised. Okay, so E4. E4, the committee has 180 days within which to file the petition to the Borough County
So
Civil
we're
Rights.
gonna go back to the clerk.
Yes, definitely.
This is going back to the point.
I think that's what,
Yeah.
and the clerk can designate somebody else to receive, but the responsibility is on the clerk. That's very typical.
I thought,
We are
talking about clerk or their
designee.
designee.
That's fine.
We skipped over Romanet.
There's no changes.
Yeah, there were no
Do you
changes.
wanna
Well,
discuss
I
it?
think we did discuss that because last time we were, we were talking about circulating the petitions, but you can do that throughout, you can take a stack of them and divide them up to other people to take. Here, the circulator has to verify that all of the signatures were fixed in there, his or her present, and the circulator believes to be the genuine signatures. I mean, that's just placing.
You think it's too restricted?
Yeah, and we all know how petition drives go. You give a handful of petitions to people who go through the community and every individual signs a petition, but you know, to have a circulator have to say, I'm affirming that this person that I handed it to is the person who it is, I think it's much too
How do you
restrictive.
do this then, Chris?
The way we always have done.
I haven't done a petition.
Okay, no, what I'm saying is you're having these signatures verified by the supervisors of election. Therefore, there's no need to have this wording in there.
It came out of some troublesome petition drives where people were forging signatures. It was added as an additional protection. But I tend to agree with you. The supervisor election is certifying the signatures. It's good enough for them, good enough.
I think that's sufficient.
So let's take it out. Take it out. I'd like to make a motion to take out Romanet. Romanet 3.
Second,
Burdick second,
Burdick second.
all in favor,
Uh,
all opposed?
Paul, you're doing good. Keep going.
Okay. In F. The committee pays the supervisor elections the cost of signature verification and the supervisor issues. We heard that the supervisor would issue a certificate as to compliance with the provisions of E, which are the,
But who's gonna collect the money? Is the clerk gonna get the money? He or she's gonna pay it to supervisor elections, or people are gonna deal directly with the supervisor election?
I think in the past, what has happened is the petitioners have to pay the supervisors of election.
Directly.
I think we heard that tonight.
which is really more convenient, because why should we be involved in that? There won't be an election. If they don't pay them, we don't need to be in the middle of it.
So this is
My
correct.
opinion.
The payment is already was good for the patient.
G,
Just, what is, it says 100, 371.11B. Does that establish the verification? Because he was saying that it goes up and down depending upon.
but it doesn't establish the amount. It's the, all that statute says is that each supervisor of elections shall post the cost on his or her website. So that's why I tied it to them. But again, that statute is also tied to constitutional amendment petitions.
Why don't we just say cost of citizen verification established by the supervisor of elections? Right? Shall complete a certificate as to compliance with provisions of subsection E.
Can I ask a question on that one?
Harrison.
Why are we pegging this to the payment? I mean, clearly, obviously, you
I
have
didn't
to,
get that.
I mean, obviously, we understand procedurally that you have to pay to have the petitions certified. But I don't think that we even need to make an explicit reference to the payment to the supervisor. I think it's so long as the supervisor has verified the petitions, a thing that they will do upon being paid.
Can be interrupted.
Yeah, so I said it's redundant.
Yeah.
But so you want to take out the section where it says you have to pay the supervisor of elections.
Yeah, it's.
But keeping that in there would at least let the people who are circulating the petition
No, it's
know
gonna
that
cost
they're
them
gonna
money.
have to cost.
I like the.
Yeah, that's a good idea.
I don't mind complicating it or flipping it around, but I do think that people should be on notice that they're gonna have to pay for the certificate. So we're gonna, what are we doing? That's.
I feel like the consensus was to leave it, but so we're not gonna make a motion.
Okay, G. So the city commission decides at a regular meeting after 6.
Hold on just one second.
You just-
Certified mail is still a thing. I mean, we still want to send things by certified mail. Pony Express or whatever. That is still a valuable tool, certified mail.
Where are you?
At the bottom of Romanet flew by. I don't know, I'm just asking the question because it's been a long time since I got certified.
Where are you? I don't.
The bottom of Romanet, making me say that word over and over. again.
Promptly for a copy of the certificate.
Last sentence, the
By
last
certified.
line on the page.
Got it. Well, I think the certificate is issued to the community so that.
That's fine. The question is, by certified mail, return it. I don't know about that. That's what I was asking.
Oh, I'm sorry, the copy is sent to the community. Excuse me.
How else can you do it? What other form that you can really?
Electronic, electronic.
Well, you know, you could do it that way, but how do you?
You know that they received.
Well, actually, you know, we do contracts.
I mean, you could send it by email, return receipt, you know, with a,
Make them confirm they received it.
well, I mean, you can ask for, on an email, you can confirm receipt. There's a.
Yeah,
thing.
I agree with you.
I don't know
I don't know why
They can
we're
actually sign.
identifying.
how we notify it.
It sounds, from what I understood, it sounds like the supervisor would issue a certificate to the committee. And then city needs to know about it, so.
Well, and they sent the
Copy
copy to
to
the
the
city.
city.
That's it.
So the question is do we need to specify how?
I don't think
No.
so.
Let the city determine.
Well, does that trigger a date? But I guess it's the date, it's the date that the
That it's
certificate
been
is
filed
issued.
and certified by these, right, by the SOEs.
But if this is our
And it would
roadmap,
be on there.
Somebody's here from the
The
clerk's
access
office, right? You're from the clerk's office.
Yes, I am.
Do you guys have a preference on, do you want things certified, returned? Do you have a preference on it? Do you have a feeling about it?
I'm guessing this is for payment. That's why it's certified mail versus regular mail.
It's not,
We're not paying.
this is for receiving the results of the,
Of the elections.
signatures.
Let me ask you a question.
I don't.
When the county certifies the outcome of the elections, how do you receive that notice?
It is sent via mail and electronically email.
Without any certified or just sent to you by mail and or electronic communication?
The mail is certified. The email is just a regular email.
Jackie?
I'd like to make a suggestion. I think it's ridiculous to do things by certified mail. I'm sitting here thinking all the multi-million-dollar contracts that we deal with, where everything is signed electronically, and we're worried about getting a certified mail. I don't like this being in the roadmap of saying it has to be like that. So it would seem to me that we should just depend on electronic communication that has the verification of receipt. I mean,
I
certified
don't
mail is
think
kind of
we have to do
ridiculous.
that detail.
Pardon me?
How is it? I don't think we have to even go to that kind of.
Well, I'm bringing it
detail.
up
So
because
what
Richard
is-
brought it up and I wanted to give another
The
alternative.
clerk,
So it is provided via email. It's provided both ways, and we use the email copy.
Is there any verification process? Do they sign?
All signed.
What did I say, Chris?
Yeah, I hear what you're saying, Jackie and Richard, but how do we verify that they've actually received it? Because you can put a return receipt on an email, but that's not always, okay, but I'm just saying, it's one document,
Right.
we're not talking about 100 certified letters, and in that way, someone will know that it had been delivered, it hadn't gone to spam, or hadn't been somehow diverted.
Most of the programs that I use, Chris, you give the client or the people 24 hours to sign. If they don't sign, you as the sender get an automatic, this person hasn't signed yet. And you
Okay.
can, so there is a
But that's
way.
like a DocuSign document.
Yeah, well, there's plenty of,
Yeah,
yeah.
I know what I'm saying is, but then you would have to put it in because the DocuSign is different than just a plain email. Maybe I agree that we're just getting
Too much
into
of
the
weeds.
weeds as to how, just say that it's been delivered, but I do see utility of a return receipt.
Electronic
signature.
verification.
You have someone that said.
Well, why don't we say that? It's delivered to the petitioner's committee, with verification of receipt or something like that.
Yeah,
we can just leave it like that.
The language is actually in here. It says return receipt request.
I know that's not questioning whether, because that's a mail, it's a receipt request is, is mail.
Well, we're probably gonna send it by email anyway, that's just a verification, so the committee can't come back later and say, we didn't get it.
So why don't we just say receipt of the certification shall be verified by the petition committee.
Or give the option of certified mail or a verified electronic receipt. So you can do it either way. I mean, because it's in there, so
No,
we're
I
talking
agree
about
with
it.
that, a verified electronic receipt. Because we do everything electronically now in the courts anyway, but there are situations where, the dog eats the homework.
The dog eats the homework.
Yeah, you heard that? It's the greatest excuse for kids in grade school.
No, that's not their work.
Oh, eat the homework. Okay,
Yeah.
gotcha. I thought you said
Okay,
homeowner.
so what are we doing on this?
I don't really have an opinion, I was just focusing the various options, but I think there should be some way of verifying that they have received it. So they can't come in later and say, oh, I didn't, you
So
can't.
why don't we just say a copy of the certificate shall be sent promptly by the committee to the committee and to the city clerk, received by the committee and the clerk shall be verified, something like that. Second, Harrison?
That works.
Good,
I would make.
Judy? Good?
Whatever works, clerk's office works for me.
Okay, I make the motion that we do that.
Second.
Who's second? That was
I'm
Harrison.
sorry, Harrison, second.
Thank you.
Very quickly, can we get? the-
All in favor?
Aye.
All opposed?
Change room net two to take all that. Make it simple, right? Simplify it.
Yes.
So we're gonna leave all that language in about section 137. Okay, same, we're gonna change the same language here on the verification at the end of room net two. For the verification.
Did that well, Rich.
Do what?
Roman N.
Well, eventually I'm gonna stop, forget what I'm talking about. I'm gonna Romanesque, I don't know, I'm gonna stop and forget the word.
Let's talk about meeting. So the city commission decides at a regular meeting after 6 o'clock. I put that in because of our discussion about what is a regular meeting, when does it start, is it earlier than 30, but motions and resolutions and ordinances have to be after 6. And I actually have I have a different proposal for, you had also asked for putting or defining what a regular meeting is in the charter, and I have that coming up. But meanwhile, I put in after 6 to make clear that it's what we call now a regular.
We have a section later on here that talks about establishing a regular meeting, don't we?
Yes. It's being amended.
313, right?
It's proposed to be amended consistently in the ordinance that's already on the books. So I'll get to that in a minute. Or we can talk about it now if you want.
Well, because it relates to this, right?
Yes. And that's why I propose amending 3.13 to mirror the ordinance from the code that is already on the books. And I somehow that didn't get into the agenda, but I have copies for everyone. Right. Yes. So this mirrors what's already in ordinance. Thank you. Now, of course, you can recommend that the city commission change this however you like, but since there is also already an ordinance in the code, I thought it might make sense to make the charter mirror what's already on the books. wanted to go with the charter.
I think we discussed this issue, I mean, this is off late to later, but this whole issue, the idea of putting in the charter, the time the meetings start and the day of the meetings. It's gotta be- I just,
I have a problem. with
I understand that there's been some monkeying around with this, but so maybe that's a putting this in as a reaction to that. But, I mean, normal city commissions, they establish their meeting dates, annually by resolution, and they're done. Meetings, and special meetings, and regular meetings, and secret meetings, and what's the other kind of meeting?
I want to go to see.
Conference meeting and, all that, it all.
But the conference meeting, they don't take public input. I think that's what we discussed.
No, they always take public
Or they
input.
don't.
I think the way.
No, the problem was
We
at
don't do
conference
legal
agendas,
business.
you don't cast a vote.
Yeah.
And only the evening meetings. So the way they treated the last petition was, they said it had to be considered at the 1:30 conference meeting because that's the next regular meeting. The problem with that is you can't vote. So
Yeah, that's what generated this.
that's what generated this.
So
So the difference is if you have an item that needs a vote taken, it needs to be at this, the night meeting. It can't be at the conference agenda meeting.
but that's,
So how do you
but
do the
that's all made up
clarification?
stuff. I mean, they made it up that you can only vote after 6 o'clock. And that's just a made up thing. There's no law about that.
By ordinance.
Oh,
Yeah,
no,
but I
I think
mean, they're just making it up.
it's always been that way legally.
But that's what we're saying. It's that it's an ordinance, not in the charter. That's what Richard's saying.
And that section goes back to, well, it's been amended, but it goes back originally to 1953.
Oh, that was the problem
So-
with them. Just this was 1983.
I mean, honestly, I don't have any concern if they want to have the conference meeting, which is like where they talk about things. But they should establish regular meetings and the petition should be considered at the next regular meeting.
Regular
That's-
meeting where you separate
A
a
regular
conference
meeting.
meeting being different than a regular meeting. That would clarify everything. And that way, we're not limited to putting time in. It's just
If they decide to have
clarification.
their meetings at 5 o'clock or who knows what, I mean, it just shouldn't be in the charter time of their meeting, so.
Right.
Probably even better language. I'm not gonna come up with it where it's a meeting in which they're actually voting on
I mean, if you
ordinances.
talk
and
about a
whatever. Instead of
regular
just saying
meeting,
regular.
talk about a regular meeting, just like municipal, but it's a meeting. It's just,
Right.
it's a meeting where people vote and they have the pledge of allegiance and snacks and all that. I mean, that's just the way it is. And the idea that you can't vote at a meeting,
Right. What they treat as a conference agenda meeting is
There's
almost like what
snacks.
you think of workshop meeting.
right? That's right.
Because that's what,
I thought it was
we're
not
used to the unilateral around the county.
That's what I thought it was for.
And maybe Anthony can help, but since I'm not the land use guy, but I believe some land use decisions have to be after
They do. After
Yeah.
6 o'clock.
6.
Yeah.
Or 5,
That's
6
different,
o'clock.
right?
Yeah, we're excluding land use items from the petition process anyway.
Right, but that may explain why resolutions, ordinances, and motions are after 6. Maybe really.
It's always been that way. As long as I'm here.
What do you tell me?
Just leave it in after 6.
I think we're reinventing the wheel here. Let's just leave this.
Leave what?
Well, that's not what we're,
No,
that's not what we're talking about.
Plus, partially because the corollary is what we do about 3.1.
right, you want an action meeting versus,
But then again, if they don't vote on it, then it'd be considered rejected under this review fall, and therefore would go to the initiative. So. Then if the city, if the city is in favor of it, they would put it at a meeting they could vote, but if they don't, because it went to
Why
the.
don't we just say by voting at its next regular meeting, period? Why do we have to put a time? Let's say they have a regular meeting at 2 o'clock.
you just need the clarification of a conference agenda meeting versus a action
Okay, so we can clarify that in
Regular
that
meeting.
section. We can say a regular meeting shall be, by study. Conference meetings may also be held for, we could clarify that, but I mean, I tend to use just the word regular meeting for regular meeting.
I agree.
Unfortunately, what transpired was,
Could we could say somewhere, a regular meeting at which motions, resolutions, or.
Let's do
say
that.
the next regular action meeting.
Except that action.
Okay.
It's just regular
So
meeting.
let's just take
Everybody
out the
knows
6
that.
o'clock in
No,
this section. for the
Because
purpose
that's
of looking at it,
exactly
we'll
what
deal
we,
with the
that's why
meetings.
we're here,
I think you have to do what the snacks are served. Snacks are served, it's a regular meeting, if there's no snacks.
They serve snacks at.
The planning council, they have bagels.
I know. But you have
Put
to
that in
charge
charter.
at your charter review meetings at the county.
Oh, we had delis.
Yeah,
Large delis.
that's what we used to do at the,
Is anybody here from the city that could provide us with like deli platters, that,
we used to do that.
new delis opened up here? There's no budget for that.
I think the liquor might be a better objective for this.
We used to do that in David, we had the deli platters.
Oh, at Sunrise, they used to have,
Yeah.
during the John Lamello days, the city commission, no joke, used to meet in John Lamello's private office. And they were actually sliding bookcases in his office. And the city commission used to have like big Italian dinners before the city commission meetings in his private office behind these things. And they would talk about everything. And then they'd go out to the meeting and it was like, hey, here's our meeting. But literally in his office, there were sliding bookcases and doors and stuff, but they always had the big Italian dinner before the meeting.
Thank you for that, George.
I know we want to move on from this point of Romanet 1. Is the term public hearing used throughout the charter? Because I feel like that also might thread the needle on this.
There's a difference between public meeting, public hearing, and a public meeting.
Right.
You could have a public meeting, which is not, a public hearing is one where, like a zoning ordinance needs to be
Advertise.
advertised. But you could have just open to the public, which is.
Right, public meeting. So I think, and maybe I'm wrong on this, but isn't it probably in the best interest policy wise that if something does get through the particular process, clearly 1,000 at least members of the Lauderdale electorate have wanted to see some action, let them give public testimony.
Well, under the, so new state law, before they take any action on any item, there's got to be an opportunity for the public to comment.
Right. My only concern is that as we're trying to kind of like thread that needle of, is a regular meeting, a conference meeting, in which no votes are taken? How do we make sure that there is not just opportunity for public input, but a vote as well? And I think by mandating it as the next public hearing might solve both those problems. It might cause others.
I've been involved in situations where the city commission doesn't do anything. So there is no vote, which ends up being, they're not putting it, they're not adopting the ordinance. And that's the way fall has it set up, which is they don't take action on it, then it moves on to the next step.
Madam Chair, if I may.
Yes.
And also, as you say, it may cause other problems. We have a quirky thing here for public hearings. There are additional advertising requirements. So I think it's, I can't remember, 12 days and then 7 days or something. There's a different provision in the charter, in the miscellaneous section near the end of the charter, that if something is called a public hearing, it has additional advertising publishing requirements for it. Which is not insurmountable, of course, but it's one additional thing that has to be done. And the agenda is not enough. There has to be an actual publication of ads. It's a public hearing.
No, I understand that, but, and again, this is just my ignorance. Public hearing items appear on those same regular agendas.
Yes. And those public hearing items were advertised pursuant to that section.
I'm okay with, if that is the extent of the additional burden, I think that actually is a good trade-off for what we get in return. I don't know if anyone else agrees.
So you would want to put something like shall after hearing from the public promptly?
Or just in Romanet 1 under G, in supposed to next regular meeting, next public hearing. Or public hearing item at its next regular.
But I think the problem with Paul is a public hearing tends to be a term of art. I mean, if the public has a right to comment, isn't that enough?
I don't think they're relatively wrong.
Let me ask the clerk, when you put together the item, how do you deviate, how do you separate the conference agenda in the afternoon versus a regular meeting at night?
I'll defer that question to the city manager.
I set the agenda.
And every item on the agenda is set by you,
Yes,
on every agenda.
yes. And the way I do that is, there's a topic that needs to be discussed that doesn't require a vote within the conference. There's a study, a report that's in complex, requires experts, place that in the afternoon. And typically we get direction from the city commission on what they would like us to move forward with. In the evening, it's all about votes.
So if you have an item that you knowingly needs a vote, such as this petition item, then you would automatically then put it on the night agenda, not the conference agenda. Right.
If there's an item that requires a vote, we would put it on the night agenda. However, there have been instances that a topic is as complex that there are certain elected officials that requested to be in conference first.
But if this is the petition initiative that's been approved by the city attorney, that then is going to the commission for a vote, then would be his responsibility then to automatically be the regular meeting, would be the night meeting, correct?
The regular meeting doesn't have to be a meeting. It could be a-
Yeah, but I'm saying, if that's the way he puts the agenda for the afternoon meeting versus the
Yeah,
night
but
meeting.
what he's saying is that some commissioners might say, you know, this is a hot topic, I want to hear it in the afternoon, and it doesn't get on that agenda. I think the charter should mandate that it go on. I mean, again, I'm back to this concept of regular meetings in the world other than Fort Lauderdale are regular meetings. There's just no
Well,
question about that the county commission meets on a certain day, certain thing, and that's a regular meeting. They have other
Right.
meetings, yes, but there's I think you should go on the agenda for the next regular meeting period. That's it. For a vote.
unfortunately, that's not the way they treated the last one.
I know that, but
But if I might, but if you do that, it could be at 1:30.
yeah,
Because that's the beginning of the meeting. It's actually one meeting on that Tuesday. It isn't 1:30. The exception being that action is taken after 6, but it's all one meeting. And for convenience, the afternoon one is called conference because no votes are taken, and the evening meeting is called regular, but that's by custom and for convenience.
So
So-
why wouldn't you go on the action agenda and someone had an issue for discussion, then it gets pulled for the discussion, but still remains on the action unless they.
Can I ask a question?
What's the question?
Um, so to the city manager's point, the reason why we have, I mean, I've been on the commission for 3 years. And it's really a convenience to the public to have the conference meeting, to be able to air out complex issues and subject matter areas. Because if we left it for just the evening, we'd be there till 4 in the morning. And it's meant to allow the community the opportunity to be able to have a full throated discussion on a subject. And then if the commission decides that they want to vote on it, they plan to add it to the agenda in the evening. And that's been the custom. I've been on this commission since
But the
20.
city's been picking and choosing what goes on conference and what goes on at
The
night.
commission decides.
And,
The commission decides that.
well, Greg just said he decided.
He decides that he does,
So he does what?
by charter, he creates the agenda, okay?
And I think, and he does it in consultation with members of the commission as it relates to an item that's important to them. And, but in the end, you know, the charter says he creates the agenda. I'm not quite sure what you're looking for here in making a change. I've been listening, I mean, maybe what you're saying is helpful. I don't know. I haven't really understood why you want to make this change. What is the change you're looking for?
But this came up and there's consensus here, not one person. The issue came up when you do a petition initiative. And they get the signatures and it's been verified, then it gets brought back to the
The
commission.
commission discusses it.
So the question was, the charter says it goes to the next regular meeting. Therefore, the petitioner of the petition drive assumed it's going on the agenda for a vote before the commission and discovered that no, it didn't. It went on the afternoon conference agenda where a vote couldn't be taken, and then they were told that that's your regular meeting. So we wanted clarity because
So
they
you're
have the
saying-
right.
So you're saying that all petition initiatives that need to be reviewed by the city commission should only be discussed in the evening because that's the time in which it would be voted upon?
That would be when the action would be, if you want to pull it off and have the conference meeting, you can pull it off, but they know that they have the opportunity that it's still been published to the public for the night meeting for action.
I don't know if that's very efficient. I think that is counterproductive. I don't know who's asked for that. All the years I've been on this commission, no one has ever asked that of me. And so I don't know where this is coming from, but it's up to you folks what you want to recommend. But I've never found anyone. I mean, let's say the petition is 1,300 or whatever number of signatures or percentages of the commission, all right? We take it up at a conference meeting and the commission, first of all, we hear the opinion of the city attorney as to whether or not this is sufficient. If the city attorney says that the question is sufficient, it's constitutional sufficiency, that the number of electors have been are sufficient to move forward, then the city commission makes the decision whether or not it wants to put it on the ballot. That's not informal. If they decide not to move forward with it, then it's not put on the evening agenda.
But it goes
Well,
on
we
the
changed
ballot
the process.
And it goes, no, that's not what we found.
I know, but the way this works is,
The way the proposed amendments
the
were,
way that it's basically, there's a petition, right? It's certified, all the petitions are gonna be reviewed by the city attorney before they're circulated.
Before they
So
go
it
out.
all
I
comes- they
get that,
have
So it's already
they-
legally
they
sufficient.
have their signatures,
right?
they're presented to the city commission. If the city commission does not enact the ordinance within 45 days,
Right,
it gets put on the ballot.
okay.
Or repeal the ordinance within 45, it's automatically put on the ballot. That's the way that. it works.
Okay,
That's
so
the way most of these
that
work.
is a substantive change.
Yeah, that's the way most of these work.
Yeah, I get that. Okay, that's fine. I have another question about that, which I've been holding back on. Let's say the petition is to remove a city commissioner or mayor. Let's say they want, does it take 1,300 people to create a recall referendum?
Different, recall referendum is different.
Well,
than this.
that's
This
not what
is,
it
this
says
is
here.
just that we're not considering.
No,
What we're considering is invitation or
What?
which is a total separate section.
I
of
know, but
statute
it
that
should be
is-
clarified here because there are exceptions here. And it should be made consistent. That's all I'm saying.
By law, the recall process is
recall
totally
process. The reason
separate,
that we didn't-
independent and different than
It's
this.
confusing, then we should talk about it, but normally a petition is to either enact an ordinance or repeal an ordinance. That's it.
I understand that, but you go in, this 3.15A
Yes.
talks about except changing zoning, changing salaries of officers or city employees, prohibited uses.
But it says electors of the city shall be empowered to propose ordinances.
Yeah.
Commission.
I understand that. I just wanted to be clarity. Yeah, that's all.
We wouldn't-
Yeah,
we
we
wouldn't
discussed that
normally
last-
remove the ordinance, we normally remove somebody from office by ordinance.
I understand that, but can 1,300 people request that it be put on a ballot as a ballot initiative? if the city commission does not approve it, and then go on for 45 days.
He's talking about it being a removal of office.
And removal of that commission.
I was asked, I would say that the recall process is covered by, it's preempted by state law. You have this whole.
I understand that, but I just don't want there to be any misunderstanding as to what is referendum.
It's totally different sections anyhow.
I understand
The
that.
charter. And what we've
Well,
been
if it
saying
gives
is
any
basically trying to keep
Comfort
everything.
to the mayor, put it in. I don't have any problem.
As long as there's something, I just don't want there to be anyone saying that there's inconsistency in our charter and they take it to the judge. The judge will say, well, it's going to be construed against the author and we're going to just allow that to go
Well, if
forward.
we think that it's confusing, I think that we should clarify, because that's not our intent.
Well, the peanut
And
gallery
that's-
is discussing this and it was confusing.
I don't know why they're
That's all right.
discussing that because it's a whole different section of the
Yeah, I just don't
charter.
want it to be any confusion with regard to this. I appreciate you letting me speak, I think.
Okay, so I have two suggestions. One suggestion is to clarify it in the ordinance. The other thing is that we did in Broward County Charter, we put a couple of footnotes. And we put a footnote that says, for clarification, we want to make it clear that this process is not available for removal of elected people from office. We just did it in a footnote. We've done it in the Broward County. So either way, I'm fine. I don't
That's
want
good.
to be confused.
Our goal, and we've said this since January, is cleaning this up so that we are not in conflict with state law. We've had too much that's been.
I would be
conflict with state
interested
law.
in what the city attorney's office would say as to whether the recall provisions of state law preempt anything that would be done by charter.
I'm not quite so agree with you.
I'm not suggesting, I'm just saying that I wouldn't want to rely on what my thoughts are. I would like to know that it is preempted, because then if that came up and it was preempted, the city attorneys should say it's not appropriate, it's preempted by state law. That would be the right thing to do. But I don't want to create more confusion. That's the last thing. So on this one, Paul's going to get back to us on whether there is a preemption for recall. And that should be on record, if there is a preemption. And my feeling would be to clarify this section and say that upon receiving a certificate determining petition, the city commission shall promptly consider the proposed initiative ordinance or reconsider the revised ordinance by period. And if the next sentence says that this commission fails to adopt it, it goes on the ballot. I don't think you have to specify what meeting it is. They either adopt the ordinance or repeal the ordinance. And if they don't, it goes on the ballot. I don't think you have to get involved with whoever meeting.
I like
I agree.
having it concise like that.
Okay, so let's do that.
Because if they choose not to even,
They don't want to hear it. They
Yeah.
don't, and that may be. They may say, just let it go on the ballot. We don't want it, maybe very controversial politically. People don't want to talk about it. That's okay.
now we're gonna put a footnote in there that just does not.
Yeah, I'm gonna put in a footnote to the first section, 3.15 A. It's gonna say the power to the procedure in 3.15 is not intended to apply to the recall of municipal officers. That's it. Shall not apply.
Thank you.
Finally shows online for 10 o'clock. My reality shows.
Why don't we just finish up with 3.15 and
Pardon?
why don't we just finish 3.15 and then come back to do the rest? Unless people want to continue on.
Finish 3.15.
Yeah, I agree with that.
At 7:30, I know, like 7:30 deadlines.
In G1 though, for clarification, to recap, so we're gonna end that first sentence at ordinance.
Yes. If they fail to adopt it. No, Rich failed back on the presence of the text, and the do the record, that's on the, they'll fail to adopt it, but right, it goes. That's it. Good.
Okay, we're pretty much at the end actually.
Let's finish.
The rest is as was presented last time.
Well, number 2 needs to be changed, because we had a big discussion about number 2. Because it's not gonna be done within 45 or 60 days. That whole thing needs to be changed. So take the title of the ordinance, I think that's not necessary because the state law requires how things go on the ballot. You have to have between words in the title and 45 words in the body. So I don't think we need that added. But which the pro and against, I mean, that's
From the current.
you think you need that at all? Jack, I think that.
Just to specify how the form of the ballot.
See if that's covered by state law, would you, please?
Not, but okay, last. Just based on discussion, some of the discussion from the last meeting, there does not need to be a financial impact statement. There's some that was brought up. The county does require one for charter amendments and the law requires one for constitutional amendments. I'm not aware that we have to do anything like that unless you want to.
Did that,
And that would be a burden on everybody, what it cost.
well, what they would do is just put, it was actually Eileen Lieberman, put cost on the impact, so the voters knew what they were voting on, understood that there was a cost impact. That was just in parentheses, a cost impact. So,
And that's on charter amendments, so not necessarily on initiatives, so as I understand.
right, because initiatives is turning over the ordinance for charter amendments.
But there's some
Right.
discussion on last meeting. That is all I have on 3.1.
So for next time, we're gonna go to. To 303, 313, and
So let me ask you a question about 313.
Yeah.
313, then instead of mirroring the language from the ordinance, the only thing that 313 really needs to address is what's in the third paragraph about prescribing rules and.
well, respectfully, I think we're gonna have a little discussion, a bigger discussion about 313 as to what should be in the charter, what not to be in the charter. About meeting, regular meeting, conference meetings, and snack meetings.
So I'll leave that.
Obviously, Richard's getting hungry.
I'll leave that for now.
Chair, just wanted to just mention, your next meeting is scheduled for January 4th. Because your meeting's regular dates is the first Thursday of every month. Knowing that that's the first week of the month, is everyone going to be here for that date?
I won't be here.
Okay.
I'll be here.
Okay,
I will.
all right, so Jackie, you won't be here, but everyone else will be here, so we have a quorum to move forward, everybody, okay. So I will make sure the only thing, Richard and myself and Paul, because we're gonna have that week of a few days off for the holiday, well, the Christmas day. Want to make sure we post that meeting at least a week before, so I'll work with Richard and Paul to get that out, at least the 22nd or the 28th. For me, I'm not going to be here the 4th, but I'm going to make sure, I already spoken with the clerk's office, that you're going to have staff here to help administrate the meeting. All right? Okay, Richard, Paul, good?
Good.
Okay.
Thank you. Do I go a move to public?
Oh, I'm sorry.
Thank you, Bill Brown, resident of the Cecil Beach. I want to thank you, especially for when it talks on section E of petitions. And I would only cautiously ask that when you come back with a percentage, it be objectively versus subjectively, because there's, when you go from, one was 15% for the initiative, dropping it to 8, and then for the referendum, it drops from 25 to 8. As a layperson and as a citizen, what was the data used to make the justification to drop those
If
percentages?
you missed the last meeting, but we discussed that we want to be consistent with whatever the state does. that's what we want to do, so that it's not up to us. And the question was at the state, it was 1%. Paul is saying that it's 8% on charged on constitutional amendments. We're going to get clarity on
And
that.
that's why
And we just
I
want
want
to
to
do,
thank you for that, because
because the more we can be consistent with state law, the less problems we have. What we do.
Not sure, can I-
Yeah, Paul.
One other thing, the 15 and the 25 were originally proposed based on the homestead, the city homestead process. So that's not what's in there currently. So it's not really,
I want 1,000.
something, good current process. So the 15, my point is 1525 is not that we're changing that, it's the vote.
Thank you for that clarification, because it is confusing.
And it varies from the last general election too, the more people that vote, the higher it goes.
Right.
Which, again, that's consistent with whatever the state law is what we're looking to adopt.
And what other municipalities in Broward County, how they're doing it as well.
Mayor,
Just one more thing, to Bill's point. So let me see if I understand this. Let's say the city commission votes to allow pickleball courts in Snyder Park. And it's a petition drive of 1,300 signatures. And to not do it. So that, and if the commission decides not to put it on the ballot, that would automatically go to a referendum. Is that kind of what I'm understanding this?
Except the process is not really designed. I mean, I guess you could design an ordinance, but it's not really designed to review or initiate specific decisions. It's designed, it deals with ordinances. So I guess there could be an ordinance prohibiting pickleball courts in
Snyder Park.
Snyder Park. You could have an it would be an ordinance to.
Right, so I'm just saying,
So they.
that, well, I certainly don't want to stifle public input. I'm just trying to figure, that could get to a point where the big, our commission is being micromanaged on every single decision it makes. And I just caution the board, I think we need to think that through because, whether it's that, I remember Mary had a petition when Jack was mayor about public spaces and, and the public being required to vote on removal or adding public parks. I just think that let us think this through. Let's think this through because I don't want to see every time someone disagrees with something, they cobble together 1,300 signatures, which are very easy to put together on almost any issue.
Well, what does the current charter say? How many signatures do you need?
Well, it's 1%, you're saying.
No,
No, but you
that
can
was
talk
limit.
about 1%.
1% is what we got from the state, what we contacted the state to
Right,
get
yeah.
a recommendation as to what they do. And it's based on the registered voters, not those that voted, but the registered voters at the last prior November
So
election.
it comes out to about 1,300.
So it came out to 13, yeah.
But at the
whatever.
statewide though, Judy, it's a lot more signatures because.
No, because if I'm doing a state legislative race, one is 1% in that district.
Okay, but
So-
let's say these folks that are trying to put together the abortion. Issue, there's a lot of signatures there.
Right, so that's all we're saying is we just want from the state and mirror what the state
I know,
recommends.
but it's, in terms of scale, it's a lot different. 1% is a lot different of the state versus Fort Lauderdale, which is a much smaller.
I would just
Okay,
say,
we would have it, it's currently 1,000.
So that's the committee, but then further down, so circulating the petition. You're saying 15% of the qualified electors in order to compel the enactment of such ordinance or amendment ordinance.
it's a big difference.
Right.
So the 1,000 is just of the initial committee.
And the 1,000 just is, right now, I think if 1,000 just says bring it to the commission. And then the commission, if it decides to move forward with it, then it goes on referendum. If it doesn't, then it dies, which is what's happening now. But you're talking about if the commission does not act within 40
55 days, it automatically goes to referendum.
So you're suggesting that for
Every
just
time.
Every time.
Right,
And that will happen.
I know.
Well, it hasn't happened historically, but think of it this way too. It's not gonna go on, ballot, anytime soon. This is gonna be open.
It's been refused. Right.
Right,
Then it's,
right.
that gets forced on. There's a big difference in 1%. I mean, there is some sweet spot between giving the voters the power to review the actions of the city commission and just like having petition after petition after petition without opinion.
Especially since it's an automatic thing now. Right now, it's not automatic, then it goes to referendum. Yeah. And I like the idea of automatic. I think it's a great idea, but I think we should raise the threshold to make sure that it's sufficient constituency base to really push forward. Okay.
Well, let's hear what this, what you come back with the state, and then we'll take it on. Again, we're just making recommendations.
Okay.
To adjourn.
Yeah, motion to adjourn. Okay.
Happy holidays, everybody.
We got it.
Okay.
See you.
Yeah.